Okay, good afternoon, everyone, and thank you all for joining us for today's month of service presentation of evictions and knowing your rights. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the month of service collaboration. Also included, we have the City of Houston's Department of Neighborhoods, and joining us today, we have Ms. Rachel Gutierrez. Also, on behalf of our presenting partner with Lone Star Legal Aid, today we have Mr. Benjamin Daly, who will be presenting the information to you all today regarding evictions and knowing your rights. But also included in the partnership, we have the Harris Central Appraisal District, Harris County Tax Assessor Collector's Office, the Earl Carl Institute. We have the Texas Legal Services Center, Houston Bar Association, and the Houston Volunteer Lawyers. And together we make up a month of service. And basically, what a month of service is, again, it's the collaboration of all of these organizations. We come together on a monthly basis and offer a variety of workshops relative to community empowerment, asset building, asset protection, and the maintaining of generational wealth. We know that there are a lot of underserved communities that are out there that don't have access to a lot of information, don't have access to certain resources, or don't know to go where to go in general when there's a question, a problem, a civil legal matter that they need assistance with. They don't know where to go and who to ask. So collectively, we decided to come together several years ago and in the hopes of creating a larger impact and reaching more people and getting this information, as much information and resources as we can out to the individual communities that we all serve. This virtual platform has allowed us the opportunity to not only reach residents within the city of Houston and Harris County, but also surrounding counties throughout the state of Texas and also across the country and even other countries in some instances. Um, we are recording the session so that we can send it out to all of the people that have registered to participate via Zoom, but we also do broadcast live on social media on Facebook so that you are able to join and tune in there as well. This is your opportunity to ask whatever questions that you have relative to evictions and the eviction process and your rights. We have a volunteer attorney that is here to answer those questions for you. However, we do ask that you try to keep your questions as general as you possibly can so that your personal detail information is not getting out there. Again, as the session is recorded and broadcast live on social media as well. In addition to that, there's the thing, certain things that can and cannot be answered on a group and a virtual platform that an attorney can't, without specific details, answer specific questions for you. So we try to ask that you keep it general. In addition to that, we just want to protect your privacy as well. Also note that information that is presented here today is for educational purposes only. It is not to be considered legal advice. However, if you do find yourselves in need, we do encourage you to reach out to our legal service partners like Lone Star Legal Aid, the Earl Carl Institute, the Volunteer Lawyers, and the Texas Legal Service Centers for any civil legal assistance that you may find yourselves in need of. So with that being said, there's a lot of information that's going to be covered here today. If you are joining us via Zoom, please feel free to type your question into the chat, or at the end, you have the opportunity to unmute yourself or raise your hand, and we can ask questions directly of the presenter. If you are joining us on Facebook, please feel free to type your questions into the chat, and I'll make sure that they are read aloud at the end so that we can get those addressed for you as well. So we want to thank you all for joining us for today's presentation. We hope the information that you get here today is beneficial for you. We encourage you and ask that you pass it and forward it along for anybody else that also may find this information to be beneficial as well. So with that being said, we are going to move right along with our introductions and get right into the presentation. So Ms. Rachel, would you like to introduce yourself and then we'll go to Mr. Benjamin Daly.
Yes, thank you, Nia. Good afternoon, everyone. On behalf of the City of Houston, Mayor Whitmire, our Interim Director, Herbert Sims. My name is Rachel Gutierrez. I should say, I am one of the community outreach coordinators for the Department of Neighborhood, Office of Neighborhood Engagement, where we concentrate on, obviously, neighborhood engagement, providing resources for you to be able to access for free in order to assist you and your loved ones with needs that you may have. So whatever the Department of Neighborhoods can do in doing so, we are here for you, and we are appreciative of your participation in these workshops. And we thank you for it. And anything that we can do, you can definitely contact me. I will put my information in the chat, as well as for those that are online and unable to, in Facebook or live streaming, I should say. I can give out that information verbally at the end of the presentation. So I thank you again for attending, and thank you to the partners for this opportunity.
All right, Mr. Daly.
Well, good afternoon, everyone. My name is Benjamin Daly. I am a staff attorney with Lone Star Legal Aid. I work in our eviction right to counsel unit. Basically, what we do is we spend some of our time helping to educate the general population about their rights, and we spend the rest of it actually in courts fighting for our clients. So if I can share screen, I can get started on the presentation. Okay. Quickly before I get started, I have to give a special acknowledgement to Kim DK, who's a fellow staff attorney who actually wrote most of these slides. So special thanks to her. And with that, we can get started. Sorry, give me one moment.
Okay.
Okay, there we go. So Lone Star Legal Aid is a 501c3 nonprofit law firm. We primarily work in Houston and East Texas counties. We represent low-income individuals in a wide variety of civil legal matters. We have both specialized units as well as some general practice units that serve special communities, such as the Veterans Unit. And we can offer anything from simple advice to full representation. So we have some information on how to apply. I'll come back to this slide, or I think there's one at the end, right? Similar information. But if you have any legal needs, feel free to contact us and put in an application. So just a brief agenda. We're going to cover a variety of things today. Just as way of introductory remarks, it's important to note that this is going to be general information, but you should be aware if you're facing any of these problems in landlord-tenant law, a lot of cases are going to turn on fact-specific issues. Hopefully, we give you a sense of what your rights are and give you the information needed that you can resolve issues as they come up. But if you do run into issues, it always makes sense to reach out to either us or Houston Volunteer Lawyers or another group that's been doing this work to ask for assistance. This is especially true if, instead of being a defensive issue, you're actually having to sue your landlord. And we'll talk a little bit about some of the causes of action that may arise in this context. So first things first are the lease agreements. Lease agreements are going to be the most important document that exists in these situations. Texas allows for both verbal and written leases. The lease is going to contain all of the terms of the agreements between the landlord and the tenant. It's important to note how important these are. Lease terms are going to control these disputes. Leases can waive some rights. They can alter some timelines. You do have a right to a copy of your lease if it's written within 3 days of signing. If you don't receive a copy of the lease, make sure you ask for it in writing. And if you're having difficulty receiving it, that's the first instance in which you should reach out to a lawyer for assistance. Now, it's also important to note that tenants who have oral leases need to take steps basically to document the agreements, because if there is a dispute, it's important to have evidence as to what the agreement actually was. In terms of what's going to be contained in the lease terms, first you have monthly rent. All leases are going to tell you how much to pay, where to make the payments. In addition to rent, they'll also say what sort of late fees are going to be involved if you pay late, or if there are any utility costs. They'll also tell you how payments are to be applied. A lot of leases have provisions which basically give the landlord the privilege of applying payments to whatever liabilities arise under the lease as they see fit. The lease is going to tell you what the initial lease terms are. Important to note, if you have a lease for a year or longer, that lease has to be in writing. There can't be an oral lease in that instance. It will also tell you if it's month to month, if there are specific terms or fees associated with that. Keep in mind, a lot of leases contain language that will automatically renew yearly leases on a month-to-month basis if you get to the end of the lease term and a new lease has not been signed. Community rules and policies. This is actually interesting. Some leases will have those actually written into the lease, but a lot of them will contain a provision which incorporates lease addendums and community rules into the lease. So you want to be on the lookout for that language. Same thing with assigned lease addendums. If you're on public housing, you're going to have a special addendum. It's something called a HAP contract. So you want to be on the lookout for that. If there are any concessions, these are going to be found in the addendums. Acts of default. This is also important. We're going to talk about this in a bit, but it should contain, all leases should contain basically the terms, but also define when a breach of lease will actually occur. These can be things like the failure to pay rent. These can be things like, conduct breaches. So if you violate the rules, for instance, that can be a breach of the lease. It can also provide for what will happen if there's an early termination or if basically there's an instance which you hold over after the lease has ended and been terminated. We'll talk about that in a little. And finally, timelines. So notice of lease renewal or non-termination. Some leases will basically require that if you are terminating your lease at the end of a lease term, that you provide a specific amount of notice. Notice to vacate. We'll talk about this a bit too. There are some notices where the actual timelines can be altered under the lease. So just flag that, and we'll talk about that in a minute. And then also give you, timelines for notices of default. So let's talk about termination of the lease. So after initial lease term, both parties have the right to terminate the lease. So for instance, if you're on a written lease that lasts for 1 year, and you're at the end of that lease term, the landlord does not have to renew the lease. They can provide you a notice terminating it. Or likewise, you can provide a notice telling the landlord that you're going to be moving out and that you're not renewing the lease. Talk about notices of lease termination, non-renewal. Lease is going to contain language about what those timelines are and what notice must be provided. A lot of leases provide the 30-day timeline for that. So basically, you give the landlord a month before you can move out. Likewise, the landlord may have to give you a month before they can ask that you move out. But that timeline is going to be contained in the lease terms. If you fail to leave by that termination date, you're what we call a holdover tenant. In almost all circumstances, you cannot make your landlord renew your lease, just like the landlord can't require that you renew your lease. Now, if there's a termination prior to the end of the lease, that's what we call early termination. That can happen with or without the consent of the parties. And there may be specific penalties if that is done not in accordance with the lease. So tenants have a few different rights to terminate their lease without penalty. So for instance, if you're terminating your lease to avoid family violence, that's covered under the property code. That is something that cannot be waived. Same thing if you're terminating your lease to avoid stalking or if there are certain sexual offenses, also cannot be waived. The code does allow for the termination of the lease in the case of a tenant's death by the estate. And then there are going to be certain instances in which a member of the military can terminate their lease. Important to note here is that each of these statutes are going to be a bit different in terms of what's required as far as notice or who's actually able to exercise these rights. So before you exercise your rights under any of these, you want to either talk to a lawyer or review the statute. Now, there's one other way in which tenant can terminate their lease early. And since we're coming up on hurricane season, I want to spend a little bit of time on this. So this is the casualty loss provision. If there's a disaster or the property is damaged and casualty loss. If the premise is made totally unusable for residential purposes and it's not the result of the tenant's fault or negligence, the tenant is allowed to terminate the lease. They provide notice to the landlord pursuant to 92.054, and then they're allowed to move. It's important to note, too, that the landlord also gains right to terminate the lease if there's a casualty loss that renders the entire property unusable. Now, let's say, for the sake of argument, you have a disaster and it damages part of the property, but the rest of the property is usable. There is not a right to terminate in that instance. Instead, the tenant can get right to ask for reduction rent. We don't normally see those, but certainly those are lawsuits that can be raised. Meanwhile, what we're more likely to see is a landlord attempt to terminate the lease altogether, even though part of the property is unusable. It's important to note that whether the property is usable or unusable is going to be a question of fact. It's also important to note that these rights actually can be waived or altered by the lease. So if you're having these issues, you should reach out to an attorney for additional information related to the specific facts in your case. Now, sort of the final type of termination that we see is termination due to a breach of the lease. And this, even though we talked about this last, this is actually the most common form of termination. And this is what always leads to, well, can lead to evictions if people don't respond timely. So important to note that a breach of lease is any violation of lease term, condition, rules, or provisions. Those are going to be defined by the lease or documents that are incorporated into the lease, such as community rules. It's important to note that the definition for what constitutes a breach can be written in a way that is very favorable to the landlord and very broad. So for instance, one lease term or community rule we see is requirement to act courteously towards various staff members for the landlord. Obviously, that covers a wide range of conduct. So you just need to be aware when you're dealing with your landlord, there may be provisions which require you to deal with them in a particular manner. You should take steps to making sure that you're not potentially violating your lease when you deal with them. So common defaults that we see, first is obviously the failure to pay rent stated by the date of the lease. Repeated violations of community policies is another. We call that a conduct-based eviction. Same thing with unauthorized tenants, where somebody has somebody either stay over or move in with them, and they're not authorized to do that under the lease. If there's criminal activity by the tenant or by their guests, that can trigger a breach of the lease. And finally, holding over. It's important to note, if there's a termination for breach of the lease, the landlord is required to give written notice of that. We call that notice to vacate. We'll talk about that shortly. Now, talk about a special problem for a moment, withholding the rent. There are instances in which we see tenants who don't feel they're being treated fairly by the landlord attempt to withhold rent to get certain services. Usually this is in response to the failure of the landlord to make repairs. It is very important that you don't do this. Withholding rent is almost always, if not always, going to be a violation of the lease. It will result in your landlord being able to file an eviction against you, as Texas law requires that rent be paid in full and on time. Additionally, withholding the rent actually is counterproductive because Texas laws require that you be current on rent if you're asking for repairs. Keep in mind that an eviction is going to be a simplified lawsuit. The only questions at play are whether the landlord has the rights to get their property back, and if there's rent, you can attach a suit for rent. There are not counterclaims involved in this. So even if your landlord owes you money or is liable to you for funds under a different statute, you're not allowed to bring that into court. You would have to file a separate lawsuit. This is especially true with repair and remedy cases. If you do need to get repairs done, the process for getting this done is you start by notifying your landlord in writing of the condition that needs to be repaired. You have to wait a reasonable amount of time before for them to basically be able to make the repairs. and only then do you gain a cause of action against them. As I stated before, this is an affirmative case. I highly recommend that you speak to a legal professional or a lawyer before you file one of these suits. Another problem that we've seen are cases where a tenant, for whatever reason, timely pays their rent and has the rent refused by the landlord. And I actually had a paralegal at our firm who does intake who asked us to talk about this. It's important to note that landlord is not free to refuse properly tendered rent under the lease agreement. They may refuse it if it's late, if it's a partial payment, or if the lease is terminated. And they may refuse it if the payment is in accordance with the requirements under the lease. So for instance, if your landlord requires a money order, they can actually require you pay it via money order as opposed to check. But other than those instances, the landlord should be accepting the rent. If you're in a position where you're properly tendering rent timely and the landlord's not accepting it, there are a few steps that you need to take in order to protect yourself. First, you always want to review your lease and a current ledger and make sure that the amounts are correct and that you're tendering in the correct manner. You want to document the date and the manner of payment. You want to keep any correspondence you have with the landlord. If need be, make sure that you're corresponding with them in writing so you have that documentation. You want to keep the payment available. So if you have a money order, hold on to the money order. Or if this is done through some other manner, make sure you keep the funds available. You want to continue to offer the rent in full and on time for future months. And you need to contact an attorney for assistance. Documentation in these cases is critical. And even if the landlord says that they are going to refuse the rent, it's important that you actually take the steps to tender it and have it refused. Now, sort of moving on to notice to vacate. This is actually, for most people, the first step in an eviction. Under the property code, the landlord is required to give a notice to vacate. 24.005 requires a 3-day notice, although that is a number that can be altered under the lease. And there are some other statutes we can talk about where that number changes. It also has to properly be delivered to you. There are, I say, 3.5 ways in which a landlord can actually deliver this. The first way is that they can hand deliver it. So what that involves is the landlord sees you, they give you the notice to vacate and place it in your hand. That constitutes proper delivery. They're allowed to mail it via regular mail or registered mail, such as certified mail, or they're allowed to post it on the inside of the door. The final way, and this is the halfway because there's a lot that goes into this, and a lot of landlords don't do this properly. They are in certain cases allowed to post it to the outside of the door. So they have to put in an envelope that they firmly affix on the outside of the door. And then they have to mail it to you by 5 o'clock the same day. The landlord has to prove that the circumstances require this form of delivery. So it's not something that can just automatically be done. Now, it is important to note that if they do not deliver things properly, or the notice does not contain the required language, or it does not give the required amount of time, the eviction itself fails. So if you are in the case where you are potentially looking at an eviction and you're expecting a notice, it is important that you document exactly how the notice was delivered to you. You can win or lose your case based on just whether or not you document the delivery of the notice. I want to briefly talk about the CARES Act. The CARES Act is COVID era federal policy. It was passed basically at the beginning of the pandemic. I think we just passed the 4-year anniversary of the passage of the bill. Under the CARES Act, certain covered properties are required to give a 30-day notice to vacate, not a 3-day or shorter amount of time. A covered property includes any property that's covered under the Violence Against Women Act. That includes Section 8 housing choice vouchers, project-based housing, rapid rehousing, low-income housing tax credit, a variety of different federal benefits. It also applies to any property that has a federally backed mortgage or federally backed insurance. So anything through Freddie Mac, Fannie Mae, if they're covered by Fair Housing Act, then it will likely be covered by the CARES Act. This includes both multifamily properties as well as single-family homes. For larger properties, there are going to be databases available to look at this. So for instance, Freddie Mac and Fannie Mae have search tools. There are also other ways in which you can find this information, such as looking through the property record. This is one defense where if you believe that you have a CARES Act defense, it is actually particularly important that you speak to a lawyer. This is still good law. We do, however, often see it challenged. And then there are certain barriers to actually making sure that you have documented that the property is covered. And so you may need assistance on that. So I would urge you, if you believe that you're covered under the CARES Act, to reach out to an attorney. So we've gone through the termination. We've gone through the notice. If you are still on the property after the notice to vacate deadline has passed, your landlord gains the right to file an eviction. The fancy name for this is a forcible detainer suit. An eviction's primary focus is to deal with the right to possess the property. So that's the basic question in front of the court. There are basically 4 elements to determining this. The plaintiffs have to show that the owner, they have to show both a lease and a breach of the lease. They have to show they gave proper notice to terminate and demand that you vacate the property. And they have to show that you have not left the property by the deadline. In non-payment of rent cases, the landlord can also attach what we call a suit for rent. Basically, that means that in addition to asking for possession of the property, they're also asking for the court to award damages in back rent. A landlord is only allowed to ask for the base rent. So in other words, if you have a lease that requires that you pay both rent and utilities and late fees, they are not allowed to ask for utilities or the late fees. They can only ask for the back rent. They are also allowed to get costs such as lawyers' fees and court costs. The case can be tried in one of 2 ways. The most common is what we call a bench trial. That is where the judge actually acts as both the finder of fact and determines what the law is. So basically, you don't talk to a jury, you only talk to the judge. You do have a right, if you're being evicted, to ask for a jury. Basically, you have to file something called a jury demand 3 days prior to trial, and you have to either pay a jury fee, or you have to basically provide the court with a jury fee waiver. So we call that a statement of inability to afford court costs. We'll talk about that a bit more in terms of the appeals process. But basically, we plead to the court that you can't afford the jury fee. However, the jury fee, I believe, is about, I think it's $50. Yeah, I could be wrong about that. And the statement can be challenged in those instances. So just be aware, if you do file with a statement, that could be challenged. Just as a special note, if you timely apply for a jury, so you file jury demand timely and you're denied a jury, you should speak to a lawyer about that. So I just want to briefly talk about what to expect if you do end up in eviction and you are going to justice court to try the case. Justice court uses simplified procedural rules, and they don't have to follow normal rules of evidence. Basically, the theory behind that is a justice court is meant to be a court in which any person can go and have their grievance heard without the need of an attorney to assist them. And so they adopt simplified rules. What this means in practice is that there's a lot of difference between the way different justice courts do business. So just be aware that, what one person's experiences in one court could be very different from what somebody experiences in a different court. It's important that when you get served for the eviction. It's going to provide you some information about when your court date is and what time it's at. Make sure you arrive on time and you have everything you need for the trial. It's also important to make sure that the court knows that you're present. Some courts have clerks that check you in at the very beginning. Others you have to wait for what we call a docket call, where they run through a list of cases that are going to be heard, and they basically check people in. Some judges also give instructions on how court works prior to calling the case to trial. So you're going to want to pay attention to that. That can be important information. Once you get called to the bench for the trial, the judges start by hearing the plaintiff's case. So the plaintiff is going to provide testimony on a number of things. And only then, after they're done with that, does the tenant have the opportunity to respond. The judge may have some questions, or they may ask you to provide evidence. So it's important that you have that available and ready to show the judge. There are some tenants who will try to get the case reset at trial. That normally does not happen. Under the rules, the main party that gets to ask for a continuance is the plaintiff, or if both parties agree, they can basically ask for an agreed continuance. So the judge hears the case. At the end, the judge is going to issue judgment in favor of one party, or they will have the opportunity to dismiss the case. You're going to want to get a copy of the judgment for review and for your files. That'll tell you information about what happened, who won, are there any damages owed, and there may be information needed to appeal as part of that judgment. So it's important you get a copy of that. Always be respectful to the judge, court staff, and opposing party when you're in court. I've seen some tenants who are understandably upset, who basically don't do themselves any favor in terms of their dealings with the parties. It is always in your best interest to be very calm and measured, even if you're upset. Just some additional notes not on the slide. One reason to get to court early, make sure you're on time, is there are judges in this county, at least in Harris County, who host different community groups to provide different services. They can potentially help you out with a variety of issues. Some judges also require that you confer with your landlord prior to actually approaching the bench. And we'll talk about some of the things that you might discuss as far as the possibility of settlement. And then much more important too about arriving early is that if you don't go to court, or you're at court late and they mark you absent, the court can issue something called a default judgment, which basically says that because you weren't present, they're going to side with the landlord. So just be aware of that in terms of planning ahead. I want to talk about settlement agreements for a minute, both because they can be sort of an off-ramp and because we've had a lot of judges sort of encourage parties to enter into settlements. A settlement can basically be close to whatever you want, so long as both parties agree. So for instance, in some cases, if you're looking for additional time to pay your rent, and you can convince your landlord to hold off on asking for judgment until you have an opportunity to pay it, that can be a settlement that you enter into. In other cases, you might just need more time to leave and you want to avoid judgment. You know, we call that a move-out agreement. That can be something you agree to. It's important to note that settlement agreements must be in writing and they must be signed by both parties. A good agreement is going to define the actions that need to be taken by both parties. So for instance, I agree to pay my back rent by a particular date. The landlord agrees that if I pay my back rent by a particular date, they're going to dismiss the case. Courts often provide standard agreements just to try and speed the process along. A lot of these are geared towards move-out agreements. If there is an instance in which parties want to take the opportunity to give the tenant the right to cure, then you need to make sure that the agreement reflects that. So it should contain both a term that says that the tenant is going to pay an amount, it should define the amount, it should find the date that the amount needs to be paid, and it needs to be clear that if the tenant pays the amount, then they don't have to move out. We do see that error happen sometimes where someone will agree to make payment, but the settlement only reflects that they agreed to make payments and not that they would be allowed to stay as opposed to required to leave. It's important when you're negotiating settlement agreements that you're specific. It's also important that you not agree to do anything that you don't know you can do. So for instance, if I'm agreeing to move out in 2 weeks, I need to make sure before I agree to that, that I'm able to move out in 2 weeks. Otherwise, I may be agreeing to waive certain rights I would have to try my case, basically in hopes I'll be able to do something I can't do. And so settlements are great things, but if you aren't careful, sometimes it can put you in a worse situation than you would be if you'd simply tried the case. So let's say you go to court at the justice of the peace level and there's a judgment entered against you. That is not the end of the road. There is an appeals process that you can use, basically to either keep your case alive or to have somebody review it, or potentially if you need more time, this is also an option for prolonging the process. So according to the code, within 5 days of judgment, you're required to do one of two things. You can either pay something called an appeal bond, which is an amount that is set by the court. Usually it is an amount that constitutes 2 months of the monthly rent. Or if you're not able to afford to pay that within the 5 days, most people aren't, you can request a statement of inability to afford court costs. This is a rather lengthy form. It used to be 2 pages, then they changed it to 12 pages. I think I've seen some forms floating around that are 6 pages, but it's not a complicated form. You're basically telling the court what your income is, what your assets are, what debts you have, and you're pleading to the court that you can't afford to pay the appeal bond. It's important to note that the statement of inability is signed under oath, so you need to be truthful in that. And it's important to note that statements can, in certain instances, be challenged. If your statement of inability is challenged, it's important you reach out to an attorney, basically for assistance and advice. Now, if you are being evicted for non-payment of rent, 5 days from the filing of the statement, you need to make a payment of 1 month of rent to the court registry. Basically what that is that will pay for rent for the month in which you are currently in. So for instance, if you had a payment that was due today, that would pay for March rent. If your payment was due in April, that would pay for April rent. That payment allows you to stay in the property till the end of the month while the appeal is ongoing. When you hit the end of the month, you then are required to make another payment of 1 month rent to the court registry, basically to pay for the next month. As long as those amounts are paid, you are allowed to remain in the property while the case goes up on appeal. If you are not able to make those payments, you are still allowed to appeal, but your landlord is entitled to get something we call a writ of possession. That is a document that allows the landlord to ask a constable to have you removed from the property. Now, once the statement's been filed and the court has time to review it, the case is forwarded up to a county court at law. The county court law will send you paperwork, so it's important that you check that regularly. The paperwork will contain language saying that you need to file an answer. An answer is a document basically where you tell the court what your defenses are. Those defenses can come in 2 types. One can be a general denial, where you basically say, I deny that what the plaintiff is pleading is true. The other is what we call a specific denial, where you raise something called an affirmative defense, where you basically say, maybe the landlord's case is true, but there's a fact that they have omitted that means that I should win. If the statement of inability has been filed, that constitutes an answer for the purpose of preventing what we call a default judgment. If you're appealing via appeal bond, you will need to file an answer that in order to avoid the default judgment that the landlord can file if the answer is not filed timely. Now, at county courts, unlike justice of the peace courts, are more formal. They are required to follow normal rules of procedure and evidence. And unlike justice of the peace court, there they are allowed to keep records. So if you've ever, for instance, seen a courtroom drama where they have a court reporter typing away, that's what we call the record of the court. That records what happens in the court. You will not see that in justice of the peace. You may see that in county court if a party asks for a record. In county court, the case is heard de novo, so from the beginning. So basically what happened in JP court no longer matters. The landlord is still required to prove up their case. The standards of evidence for proving up the case also become much more strict in county court. So just be aware of that. The judges you're dealing with are often involved in sort of a balancing act, especially when you have what we call pro se litigants, which means there aren't attorneys involved. They are required to follow the rules of procedure, but they often make concessions to make it easier for pro se litigants to plead their case. So just be aware, follow the court's instructions. If you need assistance in county court, this is an instance in which you should reach out to a lawyer. You know, these are much more formal processes, and it's really easy to get tripped up. And so even if you don't necessarily need a lawyer in JP court, even if it's a good idea to have one, county court is an instance in which you should be applying for assistance. Like in JP court, the judge is going to, at the end of the trial, issue a verdict, either in favor of the landlord or in favor of the tenant, or dismissing the case. If you lose in county court, in most cases, that ends the process. But in some cases, if there's a record and if there is an error, there is the ability to appeal it up to the Court of Appeals. You would have 10 days to pay an appeal bond. That is 10 times the monthly rent, usually due in a lump sum. However, the writ possession can issue within 5 days. If you don't pay, if you remember, we talked about the payments to the court registry. If you don't pay the payments to the court registry, there are some judges who will issue an immediate writ of possession as opposed to waiting for the 5 days. So just be aware of that as well. Briefly, I'd like to talk about public housing and subsidized housing. It's important to note that if you are in public housing or subsidized housing, there may be different terms and different protections available to you than normal tenants. These are going to be required and spelled out in the HAP contract or in federal regulations, depending on the program. There may be additional termination requirements. At minimum, you should be looking at filing a CARES Act defense. Additionally, when it comes to the payments in the court registry, public housing beneficiaries are only required to pay their portion of the rent. They are not required to pay the full amount. If there is an issue where the Justice of the Peace orders the full amount to be paid into the court registry, as opposed to the tenant's portion, there is a process for challenging that. We call that a rent contest. That is the sort of thing that I would urge you to reach out to an attorney for assistance with if you're facing that. So that wraps up the evictions side of things. But it's important to talk about a few additional issues which may come up if you're dealing with the possibility of a termination. In Texas, we call self-help, where the landlord attempts to either evict the tenant on their own without judicial oversight, or if they attempt to take steps which force the tenant out. Those actions are not allowed, but they do occasionally happen. It's important that you know what to do if you're facing those issues. So this usually comes in the form of 2 ways. So the first is what we call a lockout. In most cases, your landlord cannot change the locks on you to exclude you from the property. There are some exceptions under the property code, section 92.0081. They're also allowed to basically excuse you if they need to make repairs to the property, if the property is abandoned, or obviously if they go through the eviction process, then they can potentially get a writ of possession to exclude you. The other way this they might be involved in self-help is to shut off utilities. Your landlord cannot interrupt your utility service unless they're doing repairs or there's construction, there's emergency, or in very, very rare cases, under Property Code 92.008, they can take steps to terminate the utilities, but we'll talk about that. So it's important to note that you have right to continued utilities entering your property absent a court order, even if you're behind on the rent payments. If you're facing a wrongful lockout or wrongful utility shutoff, you are allowed to file a lawsuit against your landlord in order to either be let back on the property or to have the utilities restored. For lockout, we call that process a writ of reentry. And for utility shutoff, we call that a writ of restoration. These lawsuits are filed in the Justice of the Peace Court where you live. There are filing costs associated with those, but you can get those waived by filing a statement of inability to afford court costs. If you are facing either of these issues, again, reach out to an attorney. As you're going to see, there are damages that can be claimed under both of these lawsuits. And some of those damages include getting attorney's fees. So there are rare instances in which your landlord could lock you out. What's important to note about that is that this is pursuant to Property Code 92.0081. The landlord has to give, first of all, it has to be authorized under the lease. If the lease says nothing about a lockout, your landlord is not allowed to do it. If the landlord does lock you out, they have to give you advance notice that they're changing the locks. They have to give you a number or make available the key for the new lock within 2 hours of you making a request for the new key, regardless of the time of day. And they cannot demand payment in exchange for the key. The code is very, very specific about what needs to be done. And if your landlord violates any of it, they're in violation of the code. If they fail to let you in, you file the writ of restoration lawsuit. The first step of that is getting an ex parte hearing with the judge. Basically, that means that it's an emergency hearing. You do not have to serve your landlord, although it normally makes sense to provide them a courtesy copy of the petition. If the judge agrees you're illegally locked out, at that point, you can get the writ of reentry, ordering the landlord to let you in the home. Those are delivered via the constable, so you would want to be in contact with the office. They would then serve that on the landlord. At that point, once that's all done, you can file a separate suit to recover damages. These damages include a penalty of 1 month's rent, $1,000, actual damages. So for instance, if you had to, for instance, get a hotel room because you were locked out, or you had to eat out, or you had to, incurred any costs as part of this, then you can ask the court to order the landlord to pay you those costs back. You also get court costs and attorney's fees, less any delinquent rent or other sums. You may also have the option to terminate the lease if you've been locked out. Just as a practice note, it's important that you actually document what damages you have in these instances, because those are going to basically serve as evidence of what costs you actually incurred. And that's going to be true about the utility shutoff as well. Utility shutoff is virtually always going to be illegal. There are very rare instances under the code where it can be authorized, but almost universally when we see these happen, they're going to be illegal. Just like a writ of reentry, you file a writ of restoration lawsuit with the precinct where you live. The case is going to be set for an ex parte hearing. You do not need to serve your landlord, but often makes sense to give them a courtesy notice. That way you can tell the judge that you did notify them. If the judge agrees your utilities were shut off illegally, at that point you get the writ of restoration. Like with the writ of reentry, that's going to be served by a constable on your landlord. And like the writ of reentry, there are damages that you can recover. You get your actual damages, 1 month of rent, $1,000, attorney's fees, court costs, although these can be deducted from delinquent rent that you may have. Finally, sometimes we have issues with questions about security deposits. It's important to note that the security deposits are governed by the property code. Your landlord has the right to keep and deduct from security deposits any amounts for damages or charges that you may be liable for under the lease. Your landlord, once you've moved out, has an obligation to either return the remainder of the security deposit or to provide you an accounting for the security deposit deductions on or before the 30th day after you surrender the unit. In order to trigger that 30-day deadline, it's important to give your landlord a forwarding address. The itemization is actually pretty important too, because even if they're going to deduct certain amounts for damages, if they don't provide you the list of deductions, the court could interpret that as them withholding the security deposit in bad faith. It's also important to note that your landlord can't retain any portion covered to normal wear or tear on the unit. If you are dealing with a problem where your landlord is wrongfully withholding security deposit, this is another instance in which you would want to reach out to an attorney for assistance. Just as sort of a set closing remarks, landlords are people too. Oftentimes, issues can be resolved by getting ahead of the problem, speaking to them, trying to come up with solutions before you actually have to deal with either a termination or an eviction. And it pays dividends to avoid either of those instances. We do get questions about rental assistance. The big agencies that were providing rental assistance, Texas Rent Relief and Houston Harris County Rental Assistance, those have since closed, but there are smaller funds that may exist through different organizations such as churches. So, it makes sense to be on the lookout for those if you need assistance paying your rent. If you're having issues with the condition of the unit, make sure you're paying your rent and then contact us for help in terms of trying to get those repairs done. And then, I always say, when in doubt, ask for help. A lot of these issues are going to be fact specific. If you're running into issues, it always makes sense to try and, talk to an attorney, see if they can give you assistance. So that's it for the presentation, at least the slideshow portion of it. Our number is here at the bottom. If you need to call for an intake, you can use either of those numbers. You can also apply online at our website, lonestarlegal.org. Attorneys, if you're volunteering and want assistance or have questions, you can reach out to me at bdaily@lonestarlegal.org. We also have some online assistance. You can get that at texaslawhelp.org.
Okay, great. Thank you very much, Benjamin. Let me see if I have any questions in the chat first before I start asking my own questions. I know that with the Department of Neighborhoods, Rachel, what's typically the process that someone needs, that if they've got a landlord issue where they won't repair something or something's become uninhabitable, what's the process if they wanted to file a complaint about a landlord with the city?
Usually what they would have to do is go through the housing department. Department of Neighborhoods doesn't deal with landlord issues. But if the property is a housing property that's supplied by the housing department, then there's assistance that can be made. How involved that assistance is, I would have to get into contact with the housing department. But if it's like I said, it'd have to be a property that was affiliated with the housing department. If it's personal landlord issue to where the landlord is not providing the required, maintenance and things like that.
Utility, yeah,
Yeah.
utility and the heat
Mhm.
and stuff, something's not working. Now, I've seen in some cases too, Benjamin, where it's like if the landlord won't fix the AC in the summertime, or won't fix the heater in the wintertime, that generally if it becomes or deemed uninhabitable by the city, then they'll end up the tenant actually has to move anyway, right?
There are instances in which, yeah, failure to make repairs will make a tenancy unlivable. Um, Sometimes when you have an instance like that where the rent has been paid and the landlord is simply holding out because they want the tenant to move, we call that a constructive eviction. We may add a slide on that in the future, talking about sort of the steps there. But like this is the sort of thing we talk about self-help. The landlord is not allowed to coerce the tenant in order to leave. They have to go through the normal eviction processes in order to basically require a tenant to leave. And
Okay.
so if you are dealing with an instance in which the landlord is being difficult in terms of not making repairs, in terms of shutting off utilities, in terms of trying to make the property unlivable, it's important to reach out to an attorney because we can sort of help you walk through the process of how to address that. There may be, a lawsuit you can file. There may be certain actions you can take to protect yourself. But the worst thing that you can do as a tenant is to either withhold rent or just assume you don't have any rights and just to keep going.
So is there a process that they would have to go through if they, if the landlord doesn't fix something in a timely manner, that they can uh make repairs themselves or fix it themselves and then deduct it from the rent?
In very rare cases, they are allowed to do that when it involves the health or safety of the residents, and it has to fit under something like I think there are um, four specific categories it has to fit under that code that allows you to deduct. Like I cannot highlight this enough. Do not deduct repairs from your rent without first talking to an attorney and
Mm-hmm.
having them walk you through the process. That is a very
Mm-hmm.
good way of, effectively putting yourself in a position where you're going to get evicted. Most landlords aren't going to look at a deduction like a deduction. They're going to look at it like the rent was withheld. There's specific documentation that's required. And then it can't just be any issue that involves the health or safety of the tenant. The code is very, very specific. So I would say if you're dealing with that issue, contact Lone Star Legal Aid or contact another legal aid organization to help you. Deducting repairs from the rent may be a good option in your specific case, but you should not do it without an attorney specifically telling you in your case that you should do it.
Yeah. What happens if you've got a scenario where you've got you're renting a home, but the owner isn't paying the mortgage and the house is now about to get foreclosed on, but you're current on your rent? What happens in that kind of a scenario?
So there is a federal law about this. It's Protecting Tenants from Foreclosure Act. Effectively, what it provides is that if you are a bona fide tenant, so in other words, the code requires that the tenancy be the result of what we call an arm's length transaction for basically market rate rent. So if you're somebody's brother and you're renting an apartment from your brother at $200 a month, which is well below market rate, this doesn't apply to you. But for all other tenants, if there is a foreclosure, the new owner either has to continue on with the tenancy, or if there's an instance where the new owner intends to move into the property themselves, they have to give you a 90-day termination notice. As far as the pragmatic side of things, what I would recommend is when you are aware that there is a new owner, reach out to them, uh, tender your payments timely to them. If there are issues with them accepting it, we talked about documenting, your payments and your communications when a landlord doesn't accept the rent. and then reach out to an attorney. That's a special case that is going to require some guidance. So, but there are protections, and that I think is the most important thing to know.
Yeah, I had recalled, especially during COVID, right in the midst of all that, when people were having a hard time actually making their mortgage payments, that tenants were in the process of getting foreclosed. Well, the homes were getting foreclosed on, but they were actually paying their rents, and they didn't know
Mhm.
what their options were, what were they allowed to do. So I know that happens on a regular basis too. So, let me see if there are other questions. I believe that is, oh, the removal of property from a rent, from the from a unit when there's for non-payment. Aren't there certain items that a landlord is allowed to remove if you don't pay your rent, or some items that are protected that they're not allowed to touch?
Oh, you're talking about landlord lien, where there's something
Yeah,
written to the
landlord.
lease where,
Yeah,
um, I don't know that off the top of my head because frankly, I've very rarely seen anybody with a landlord who's attempted to take property out of their apartment.
I've seen it
Um,
on like where people were they're renting rooms in
mhm.
different people's houses and they don't pay the rent, then the landlord will go in and take stuff out of their rooms.
I don't know off the top of my head. We may need to add a slide in if that's something that you guys have been seeing. Again, I'd recommend talking to attorney in that instance.
Okay. And I don't see any other questions from, all right,
I
thank
believe
you.
somebody at the top had something about late fees.
Yeah, that was the one about the new laws for 2023, and you and I had talked about that. We didn't know of any
Yeah,
laws, but
so I don't know what specific statute they would be referring to. I can talk a little bit about what the code says about late fees,
okay, go
and
ahead.
that might be helpful.
Yes.
So under the code, the first thing to note is the late fees must be authorized by the lease. If the lease does not contain any provision allowing for late fees, then late fees are not authorized. And if they collect late fees, that's a problem for them. Late fees are also capped. If you are living in a complex that has 5 or more units, they're capped at 10% of the rent. If it's for fewer units, it's 12% of the rent. If the landlord is collecting late fees in excess of those amounts, you do have the right to sue the landlord if you've made payments and it's been applied improperly the late fees. So that's another instance in which if you see something like that happening, reach out to us or another attorney. Those are cases that, you need somebody to help you with potentially an affirmative lawsuit.
When an eviction lawsuit is actually filed, does the lawsuit only include the past due rent, or is it all inclusive of late fees,
No,
potentially attorney's fees? What's included in the eviction suit?
so you normally see three sorts of amounts that can be awarded. So the first is rent, and it is just rent. They're not allowed to add utilities. They're not allowed to add late fees. If there's damage to the property, they can't add that on. It is only the back rent. They are allowed to get court costs, and that's something the courts normally do because they're basically entitled to get compensated for the filing. They're also allowed reasonable attorney's fees if the lease authorizes it or if the attorney has pled for reasonable attorney's fees. And that's something the attorney actually has to prove up because it's not going to be pled as a specific amount in most cases. Usually it will be reasonable attorney's fees, and then they'll plead to the court that they work so many hours at a particular rate, and that's reasonable and necessary for the work that they're doing effectively.
Okay. Another question, something else I just thought about. When you completely threw me off guard when I was my daughter just walked in and she completely threw me for a loop here. Um, oh my gosh, what was I getting ready to say? She just made me lose complete train of thought. Um, it was something in relation to the fees and court call eviction. Okay, so the eviction lawsuit itself is to retain or to regain possession of the actual property. When someone actually files an eviction suit, but then the tenant leaves, are they still allowed to proceed with the eviction case, considering that the tenant is now vacated? Because a lot of people think, unfortunately, that notice to vacate that they get on their door is the actual eviction itself, and that means that they actually have to leave, as
So,
opposed to them going through the full process of court. So,
so I think there are three answers to that. So let's go through a couple scenarios. So let's say that you get a 3-day notice to vacate and you are out on day 2. The landlord is not allowed to file a suit against you because you vacated timely. If you do get notice that they filed a suit against you, then you need to basically appear in court and plead to the judge that you had already left before the filing date. And actually, this is, I probably should have added a line about documenting everything on, sort of the practice tips. Document everything. If you're leaving, make sure that you have something from the landlord saying that they've received the keys at a particular date or time, or you can text them saying, hey, I've surrendered the property, my keys are, because that protects you from the landlord going to court and potentially making misstatements about when you're out or how much is owed or things like that. Now let's say you get a 3-day notice. You don't leave. You get served the eviction. The eviction's for non-payment of rent. You leave between the date you get the citation and the court date. The landlord is technically still able to move forward because they've attached a suit for rent and they can claim those damages. And even though you left before the court date, you did not leave before the deadline of the notice to vacate. So you do sometimes see that where someone will vacate and it'll be before the court date, but the landlord will want to go forward anyway. Now, the third scenario, you get a 3-day notice, you don't leave, you get served with the eviction, it's a conduct-based eviction, you leave before the court date happens. In that case, in most cases, they can't move forward with the eviction because they're asking the court for possession. The possession has already been given to them when you vacated, and so the case becomes moot.
mhm.
In all three of those scenarios, if you find out there's an eviction against you, you should probably be attending court at minimum to make sure that the judge understands what happened when.
How does an eviction show up, or an eviction and a judgment for unpaid rent show up or affect your credit report?
It's like all liabilities in the sense that your landlord could report it as an unpaid debt. On a credit report, I don't take my word for this. I believe it's merely tracking the amount owed. It's going to look differently on a tenant screening report where they're going to track the filing as well as the amount owed. I could be wrong about that. It's been a while since I pulled a pure credit report for somebody doing these issues, but I believe most people are concerned with the actual appearance of the eviction on the tenant screening, not necessarily pure credit.
Because if I'm not mistaken, I believe on the credit report, the credit report will show up as a debt from a collection agency. It doesn't show up as a judgment for owed rent, but for the public, for the screening, the eviction does show up on the history.
Yeah, it's important to note that these are two different types of screening. Credit reporting is virtually entirely dealing with the question of what amounts of money are owed and to whom. Tenant screening, you're getting a broader cross-section of information, basically because the landlord wants to know whether or not the person they're thinking about renting to would be a good tenant. And so a lot of additional information will show up.
Okay. I hope I'm answering all the questions that I think I've gotten from previously. Just making sure. But I do believe that is it. Benjamin, thank you.
Thanks for
Very,
having me.
a lot of information. We appreciate you filling in for Ms. Kimberly DK for this month. Thank you all very much. If there are no other questions, we will relinquish the remainder of your time for the afternoon back to you guys. Thank you all for attending and participating. We hope the information that you all have received has been beneficial, that it answered the questions that you needed or addressed the issues that any of you may have had or concerns that you may have had. So if there's anything else, I will be including the contact information for Lone Star Legal Aid as well as some other resources that were mentioned along with the link of the recording of this video so that you can go back and actually watch it again. You can also go on our Facebook page on Amos Houston and also watch the presentation again there as well. Encourage anybody that's still maybe facing some kind of eviction or financial hardship and facing eviction. To encourage them to reach out or to at least watch the video or to get the information that they need to know that they actually have rights. Again, the 3-day notice to vacate itself is not the eviction. And we definitely want to emphasize that to a lot of people, that they assume when they get that notice on the door that means that they actually have to vacate, that is the actual eviction notice, and that's not the case. Encourage you also to reach out for legal assistance. If you do find yourself facing eviction and you're unsure of the process and you want to know what's going on, and reach out to an attorney. Don't automatically assume anything. Don't listen to the what we call the street committee and have them telling you all the different information that is incorrect. Of what they did when they did it or when they went through the process or what have you. Make sure that you actually reach out for legal representation and give the actual facts, so that you'll know what that you're doing is actually correct and current and accurate. So again, thank you, Benjamin. Thanks to Lone Star Legal Aid, the City of Houston's Department of Neighborhoods, and on behalf of the remaining partners with the A Month of Service, again, we want to thank you all for presenting as well as being present here today. If there are not any current workshops that we don't offer that you guys may be interested in, then please feel free to reach out to myself or to Rachel to let us know so that we can work on getting it on our calendar. Tomorrow's presentation, we have maintaining and adding value to your home. And then we have next week. Oh, wow, it's next week already. The 26th, coffee and conversation. Rachel, do you want to talk about coffee and conversation real quick?
Yes, thank you, Nia. So we will have actually the Department of Neighborhoods present. There are some new things going on within the department, and so we would like to definitely relay that information to the community. There's some new programs, there's some restructuring, so we will have several divisions within the Department of Neighborhood come to speak about the happenings of the department.
Okay, and that's going to be on Tuesday, the March the 26th at the Sunnyside Multi-Service Center located at 4410 Reed Road, and that's from 10 a.m. to 12 p.m. And I will include the information on the calendar for you all to be able to attend. That will also be a hybrid presentation. It's going to be virtual as well as in person. So feel free to join us and get that information there, and look for a coffee and conversation in a neighborhood coming to you really soon. So again, thank y'all very much. You all have a wonderful remainder of your day. Enjoy this weather while we got it. There's no telling what's going to happen tomorrow. It's Houston, so you all have a good day and take care of yourselves. Stay safe. And thanks once again, Benjamin. Appreciate your help.
Thanks for having me.
All right. Take care.